I have a very similar case. So I, some time ago, saw a couple of Filipino um, uh, people. Their regime is similar to the common law one. So based on what Francis just said, these subjects, however, were living in Italy, and therefore they were under the Italian law within a communion of property regime. One of them, the wife, had purchased a home. Well, that was not for fiscal reasons. Somehow helping those who purchase a home for the first time, but actually also in view of a possible future succession or indeed of a divorce, they really wanted to know that they were both, owners of two different homes. So a possible solution was to benefit from the system of the choice of applicable law, a retroactive one, so that a recent purchase by the wife without any mortgage, so there was no problem of protecting third parties, of effects over third parties without prejudice to what Mr. Salerno Cardillo said earlier today. So no third party effects applied. So the solution could be of two different ways. On the one hand, they could choose the Filipino applicable law without any renvoi. They could actually benefit from a common law regime. Actually, when we talk to our colleagues from common law states, they always tell us, look, we have no regime, basically. So when there's a divorce, judges may even decide that property should be moved, in order, from one spouse to another in order to obtain a fair distribution of the property. So either a separation of the property within a common law framework or within an Italian framework. They chose the Italian law as the applicable law, plus the separation of property as within a framework of convention marriage contract. So for that, we could use the private international law as a basis. That was done for some Romanian couples some time ago, because up until some time ago, the communion of property in Romania was the only way whereby they could, purchase property on a separate basis. Of course, there was an open issue there, namely what is envisaged by that given set of rules. Well, this morning we talked about the European Succession Certificate, and we said that our choices are certainly recognized and they are certainly binding for the Italian state. Based on the matrimonial property rights regulation, our choices are also binding to the other member states who have received that regulation. Of course, things may not apply to states like the UK, for example. So the choice of the applicable law is a perfectly legitimate approach as envisaged by the system. Of course, if we also want to obtain further third parties effects, protection, well, we could, because after all, litigation may be filed when, I mean, if they can demonstrate that that retroactive approach only aimed at achieving some fraud and did not include those requisites whereby third parties' effects could be safeguarded. But I mean, apart from what is normally envisaged by many of our legislations, well, we basically only used a principle envisaged by our law. Fiscally speaking, since my deed included two conventions, so I had to use the relevant tax twice, because of course the ultimate goal was to allow them to benefit from the Italian separation of property regime. So because of all of that, I simply decided I should use that tax twice. So having said that, these may all be very useful, tools. As Franz has said, we know that the need not to abuse of the law. Well, regarding this, sometimes the solution is to transfer half of the property from one spouse to the other through a deed prior to the second, the repurchase of a given property. Well, of course, once again, the ultimate goal in that case is to simply lower taxation. So within that framework, the conventional solution may indeed be the most problematic in terms of visibility vis-a-vis the fiscal agency, the tax income agency. So I'm saying this because a retroactive approach may indeed account for an obstacle, fiscally speaking. It may be about a gift or a deferred price scheme. But once again, the whole operation has the ultimate goal of obtaining a lower taxation. Having said that, well, actually, sorry, I'd like to add something when it comes to the choice of the applicable law. Well, of course, publicity may apply here because this can already be done once the marriage is contracted. So if the spouses have their residence in Italy, they may ask for being registered in the relevant Italian municipality, and then if they contract marriage, they include in their contract their choice of applicable law, even with a retroactive effect. Well, then the possibility shall apply too. So the choice of the applicable law can be written down. This can be included in the marriage contract. Let me conclude by saying that, of course, you can find all of this we've been talking about in our website, plus the streaming of today's seminar. In case you wanted to go through all to what we've been saying so far, you can have access to our website. Now, questions and answers.